to another Rose Cut webinar, monthly webinar. For those who don't know me, my name is Chao Jia, or Q for short. I'm the founder and CEO of Rose Cut Technologies, wealth planning and investment platform for the people at the beginning of their wealth creation curve through the convenience of the app and digital means. So today we are talking about a very exciting topic, the wealth planning for the future millionaires. And it has a lot of crossover topics between tax and legal and investment. So here with me are two experts in the area, Yousafa from Irwin Mitchell and Ken Chapman from EFG. Welcome both.
Thank you.
So maybe each of you could make a quick intro in terms of what you do. And I would just bring it up to say, I used to work with Ken in Credit Suisse, and he was the head of planning, wealth planning there. And, it's always a confusion to people what wealth planning is versus tax planning and other legal bits. So maybe, Ken, you can start by telling us what exactly a wealth planner does.
Yeah, sure. I mean, thanks, QJ. There's a lot of crossover, obviously, between wealth planning and tax planning. I think to try and put it in a nutshell, I think a wealth planner is someone who looks to optimize their clients' tax and legal position by drawing in experts from lots of other fields, so legal experts and tax experts. So someone that has a very good grasp of the subject, can identify the opportunities and can see the pitfalls and the risks there, and can bring in the suitable external experts as and when required. So look, my background, as you said, QJ, we worked together at Credit Suisse a few years ago, probably about 10 years ago now. I'm currently head of wealth planning at EFG in the UK. I deal with a lot of very wealthy international families from all sorts of different locations around the world, looking to help them structure their affairs efficiently and to make sure that, I suppose, assets are transmitted in the way that they'd like them to be down through the generations, so they cascade down to their kids or their grandkids or whatever stage of life they're at. And that if they're looking to invest in places outside the UK, for instance, they do so in as efficient a manner as possible.
Great, thank you for that. Actually, that already raised a couple of really good points, which I'll touch upon later on. And Yousafa, if you could introduce yourself, that'd be great.
Yeah, thank you, QJ, and good afternoon, everyone. So my name is Yousafa Hanzara, and I am a solicitor at Irwin Mitchell. I've been practicing law for about 10 years now. I might look young, but there's a lot of experience here. And my specialty is mostly international tax and estate planning. So hopefully some of the topics we'll discuss will resonate with you, and any questions we can take at the end. Thank you, QJ.
Great, thank you both. So for the people who have been to our webinars before, you will notice that today we actually starting with two real-life client cases, Noah and Raul. So, but basically we have modified some of the details. So, to not disclose identity of those individuals, but the case itself give you a very good taste of what are the really important considerations these people go through before they dive into, hey, should I buy Google or Tesla? And what are the kind of exciting investments I should be looking at? And so today's agenda, we are going to start with two client cases, and then through that talk about important considerations for the planning process, and what are the things that can be done now instead of later. A few years back, I saw a tube app in the UK showing that do your tax reporting now to find the inner peace. So a lot of people find tax as a troublesome topic, but here, to tell you, you can really use it to your advantage and achieve inner peace, if you have the right plan in place. And then we're going to talk about how to combine financial planning and investment advice for the global citizen. For the audience here, we probably have a dozen of different nationalities and people on the go all the time. So cross-border issue, both on the currency, tax reporting, and assets and everything becomes much more dominant question now. So, and then in the end, we're going to have a poll on question topics that you would like to hear more in the future, and live Q&A with our two experts here. So here, let's jump into the first case study, Nora. We lay down some basic numbers and facts here. So Noah is a French guy. He is the CEO of something genomics, and the business is doing really well and just raised their Series C, actually before all this, recent macro mess, I suppose. And his stake in the business is worth a lot, and but it's illiquid. Just like most of the founders joining this call, and he's happy that he's taken the secondary of 2 million for his lifestyle reasons, and now he has moved out of UK after spending 12 years here. So we put down some sort of tax status here, which two speakers will explain what that means, and he has basically his assets scattered around, following his trail from France to UK. They haven't bought anything in Singapore just yet, renting there with his family, with his wife and his son. So he's made some, personal investments in the UK. But now with all this, he wonders, what are the right things to put in place, because things are getting complicated. So that's a fact, and some of you may resonate with similar background or situations. And first question, what does this make you think of, Yousafa? Like, with this kind of client, what would you do when you first get in touch with them? Do you sort of like, do you check how much or how little they have done? And if they have not done much, where would you start?
So yes, thank you, QJ. So this is our typical client. So initially, once we have the initial meeting with the client, we like to know what they've done, because if they haven't done anything, sometimes doing nothing might be the answer. But in some cases, doing something might be better for that client. So we always try and add value to make sure that if this client doesn't need to do anything, we would leave them at that point and not do anything. But the majority of the cases with these clients where they have a lot of international connections and assets overseas, or their tax status might be slightly different, we take the holistic approach. So the first thing I'll do with this client is work out where they're currently resident. So it seems from the fact that he is resident in Singapore, and then look at it from a UK tax perspective. What does that mean for him? What has he finished his UK tax residency? Has he terminated his residency in the UK? What is his domicile? Because again, the concept of domicile and residency plays a huge part in determining where he's taxed worldwide and also in the UK. For just to give you an example, so if Noah, he's born in France, he lived in the UK for a bit, and now he's gone to Singapore. So the key question for a UK private client lawyer is, where is his domicile? And domicile is a hugely complex topic, because there is domicile for taxes and there's domicile for succession. So succession is mostly who inherits what from your estate. So with Noah, in relation to his domicile, we would look at where he was born. So again, he's born in France, so he would have a domicile of origin in France, but over time that would change. So if he's come to the UK, the question would be, did he make it the UK his home? And broadly speaking, domicile under the general meaning of the rules are where you regard as your permanent home. So there are clients where they might have regarded somewhere as their permanent home, but that doesn't necessarily mean that they are domiciled in that particular jurisdiction, because you look at their lifestyle, what connections they have to a particular country, where they're living, where their assets are based, where they're working, etc. So their domicile is key for that point. And because the UK looks at residency when it comes to domicile, there's another test for what's called deemed domicile. So if someone's been resident in the UK for 15 out of the previous 20 tax years, the UK will still call them deemed domicile. And the reason this is important is because if you are domiciled in England and Wales, whether under the normal rules or this 15 out of the 20-year rule, your worldwide assets are subject to tax. So for Noah, this is very key to determine at the beginning, because if we can protect his French property to fall outside of the UK inheritance tax, we should definitely be looking at that. And then planning comes in as to how you do that. So the key thing for my client would be, where's your domicile? Are you UK domiciled? If so, UK worldwide assets subject to tax. If non-domiciled, then just your UK assets, so anything offshore can be protected. So that's what I would ask him at the beginning. And then that leads on to other planning, because if your domicile is not the UK, then it's possible that other inheritance tax laws in different jurisdictions might apply to your assets. For example, again, he's got a house in France. We would then think about whether French succession laws might apply to the French property, and issues about where does he have his will, which law governs what happens to his UK assets, which law governs what happens to his French assets. So if we open the conversation around domicile, that then leads us on neatly to the question of what can be done. So those are my first points.
Great, that's a great start on the introducing the concept of domicile, because I think this is a very unique English law concept for even other countries' English native speakers to grasp. It means something very different again and again, and confuse people. So by the sound of it, he is lucky that he moved out of the UK within the 15 years rule. So he still have the option not to be a deemed dom, right? And then his future plan is pending on where he wants to live next. And so the next question I would ask is, he has a unmarried partner and their son in Singapore, right? So this brings a bit of complexity, because I understand there's some specific rules about unmarried partner versus married partner. And I personally, rushed to the lawyer's office the day before I went into hospital to deliver my son to sign my will. I feel like that has to be done, and as a risk management thing. If I tell you Noah has not done any will, what are your comments and concerns about the family situation?
Yeah, so I would be hugely concerned because, as I've already mentioned before, each country has its own succession laws about who inherits what, and a lot of the time it depends on where the assets are based, and again, your domicile. So in the UK, so speaking from an English law perspective, if you are unmarried, there's no rights under our laws of intestacy, which are the rules that apply if you haven't made a will. So this property that you might own in the UK cannot automatically pass to your partner because you're unmarried. We don't have, there's a myth about the common law marriage, so we don't recognize cohabitants in terms of succession and inheritance laws. So it's very important that a will is made in England and Wales, especially if the property is owned solely by Noah, to make sure that it then passes to the spouse. If you don't make a will, intestacy laws would apply. That means there will be a split between, if he has children, so he has on these facts, everything would go to the child, and that could have severe tax consequences, because assets passing to children in the UK are not exempt from inheritance tax. So for spouses, you get inheritance tax relief. So as long as your domiciles, again, I keep going on about this concept of domicile, but it's also important when it comes to who your assets go to, because both you and your spouse's domicile status should be matching. If there's a mismatch, then you don't get the full relief for inheritance tax. So as an example, if Noah is non-domiciled, say Noah was UK domiciled, but his wife was non-domiciled, then anything passing to his non-domiciled spouse would only be getting a relief for £325,000, would be tax-free. The rest would be taxed at 40%, because we have this cap. Whereas if their domiciles are matching, so say both of them are French and non-doms and not UK domiciled, then you get the full relief, which means on the first death, you've saved inheritance tax. And then on the second death, when you're leaving assets to the children, at least you know that you haven't paid taxes on the first death. Whereas on the second death, some planning could be done anyway to make sure that you minimize your inheritance tax, but you've got rid of that headache, if that makes sense. Otherwise, if intestacy laws apply, children get it, children will be taxed at 40%. There is that minimal allowance of £325,000, but other than that, you're in trouble with the tax man. Yeah.
So just to confirm one point, the assets is, for example, their house is sitting in the UK, and despite the family are Singapore tax resident, the UK inheritance tax rules still apply to the UK assets, right? So this is why they have to sort this out.
Exactly. So if you have UK assets, so a property situated in the UK, it doesn't really matter so much where your domicile is, because if you think about it, the taxman wants to get their hands on UK assets. So if you have a UK property, they will tax it. So for this reason, it's very important that if you want to save that tax on the first death, you make a will, pass the property to the spouse. In some cases, that might not be suitable or appropriate, depending on what the family circumstances are. But the majority of the planning could be leave everything to your spouse, save that headache on the first death, and then do some planning on the second. So UK assets are always subject to UK inheritance tax, regardless of domicile.
Good to know. And Ken, if Noah is one of your clients, and you look at these are the setup, is there anything other than the will? What are the other options and he could consider as cost effective and simple things to do today to optimize their situation?
Yeah, sure, QJ. I mean, looking just at a snapshot of what we've got in front of us, there are a couple of things that strike me straight away. One is that although they're they're very asset rich as a family, that the assets are really concentrated, the valuable assets are really concentrated in the shares in the tech business, and even the property isn't particularly valuable. In terms. So if something was to happen to Noah, there's not a lot of liquidity around. In fact, there's virtually no liquidity around at all. And so that would lead me to think in terms of the fact they need to, because of the lifestyle they're probably used to leading and the expense they have, they need to be able to generate some liquidity quickly if something happens to Noah. So I would be looking at putting a significant insurance policy in place on Noah's life. That would pay out, maybe X million pounds or X million dollars, depending on where we were at the time, and that would give the family some liquidity to carry on their lifestyle if something happened to Noah, something awful, untoward happened to Noah. And I think in the UK that could be written under trust. I think in Singapore it could probably be written under trust as well, actually, so the money would pay out into a trust and could be used for the purpose required. So that'd be the first thing I think I'd look at, the first thing that really sort of hits me. And we see that with lots of clients actually who are asset rich but liquidity poor, and if something does happen to the main breadwinner of the family, there's suddenly a lack of liquidity available to support the family with. The other thing that strikes me is the tech business itself might, I think, qualify for business property relief, being an unquoted business, which would mean that it could be exempt from inheritance tax. I mean, Yousafa will have a thought of that on that, I'm sure. But if that is the case, it would mean that it would be exempt from UK inheritance tax, and therefore it might be possible to arrange to place some of the shares in the tech business on trust for Noah's partner and child, ahead of the company one day maybe going for a main listing.
Yeah, and again, Ken, just to add to that with the business property relief, again, very important to do that in your will, because if you don't do that in your will and everything passes outright to the children, there might be difficulties in obtaining relief for that. So if Noah makes a will and leaves everything to his spouse, including the business, you don't want to lose the business property relief. You may as well do a separate provision for that business, give it to your beneficiaries who are not exempt, like the children, and then you get the business property relief on that, and then everything else can pass to the spouse. But it has to be done under a will to make sure you get that. Otherwise, there's the split between the spouse and the children.
Would you look at the possibility, Yousafa, of putting some of the shares onto a trust, perhaps now?
Possibly. So there are options. So there are pros and cons of putting it into a trust, because if, for example, I mean, Noah's still quite young. It depends on what he wants to do with the business. He might want more control over it. So again, it depends on the family circumstances, and you have to think about the tax considerations, but it's definitely an option that can be considered. So I wouldn't write it off completely. It's definitely something to look at.
Yeah, just to jump on the trust point, right? Because we have a lot of tech founders on this call, by the way, and the typical VC-backed tech businesses like Rosecap itself go through, rounds of funding journey. So it becomes a question of when it's worthwhile to spend the money to look at structuring the trust on the shares. Definitely not the first round, because despite the commitment and determination, the chances of the business becoming something big is still slim. But when you have gone through Series A and Series B, and IPO or exit looks closer on the horizon, and then you would start thinking about, how do I protect my shares in a business from a tax optimization point of view? So, what are the trigger points if you say, okay, now this asset is, valuable enough despite still illiquid because it's unlisted, that it's worth me spending a couple of £1,000 for advisor to at least look at this and potentially spend more to set it up. It's like setting up the tech stack for the tech business, right? This is like setting up the tax stack, and and this has to come at appropriate time and evolve as the situation goes. And there's also a risk of overbuild and over engineering, because you want to do it as appropriate. So what's your thoughts on this?
I would have thought that certainly the clients I've worked with in the past, I mean, one of the trigger points obviously is if you've got shares in an unquoted business that is looking likely to list on a major exchange at some stage in the near future. That's a sort of trigger point to start thinking about it, because this wonderful relief that we have in the UK called business relief, or business property relief, I think as it's sometimes known, does give exemption in lots of cases for unquoted shares. 100% exemption from inheritance tax for unquoted shares, and that enables someone to set up a trust without having to worry about facing a 20% initial inheritance tax charge on putting the assets into the trust as well. So there's this sort of point. But once the company becomes listed, and AIM doesn't count, I think, for the purpose of listing, but once the company becomes listed on a major exchange, then that relief is lost at that point, and it then becomes a lot more difficult to do planning. I had a client, many years ago now, over 10 years ago actually, who was in exactly this situation. The company he was the CEO of and major shareholder in was just about to go through a listing process. His shares, at the start of the week were shielded completely from inheritance tax, but probably by the end of the week they would no longer be. And so we talked long and hard about putting some of the shares on a trust for his kids. At that point, unfortunately, never was able to get around to it, just didn't have the time to do it in the end. So the opportunity was lost. But we sat down together a few months later, and I remember him saying, "Crikey, I just wish I'd taken up that idea of putting some shares into trust before it became too late." So I've heard that said a lot of times actually. So I think the main trigger point is making sure that you look to do it way ahead of the company actually obtaining a listing.
I think that's a great point. A lot of the founders, even including myself, always prioritize the business over the personal affairs and thinking I'll get the round to it. But there will be a point where you pass the deadline of achieving the best benefit of that. So Rosecap, by the way, is all for early prep, early education. So we know we get on to the best path, without much major downside or regrets later. And I want to bring up a point you said about the insurance, right? So that's a very interesting point, because in his UK, he has this 1 million home with a 600K mortgage on it. So worst case scenario, the bank wants the 600K back, and he doesn't even have enough liquidity to pay that 600K. And because his 300K financial assets are mostly sitting in pension. You can take the ISA out, but not the pension, right? So in this case is what we call a liquidity squeeze. where you have to fire sale your house to get the cash to pay back the debt, the mortgage. Now, if the insurance can solve that, what are the sort of steps or considerations? Who can get an insurance of a couple of million, for example? What the insurers are looking for,
Well, I
and
think
how much do I have to spend?
one of the funny things I find is that quite often when one mentions the subject of insurance, almost gets funny looks from and in client meetings sometimes. If the subject of insurance comes up, it's almost like sort of some clients think it's time to leave. But it is of course a very valuable financial planning tool to have, and in cases like this. We know, me, Yousafa and I see lots of clients in this situation where, on paper you'd think, well, Noah has actually got a stake in a tech company worth £50 million. He's hugely wealthy. But actually, if you look at the balance sheet and analyse it in more detail, you're absolutely right, QJ, that if something happened to him, he's got a property worth £1 million in the UK and no way realistically of paying off the outstanding mortgage of 500,000, because it's not like he can suddenly start selling, or his executors can start selling shares in the tech business, because it's very, very illiquid, and therefore there probably wouldn't be anyone that would be willing to step in and buy them. And so insurance is very, very easy to arrange, especially for younger entrepreneurs. It's pretty much a case of just going through an application form. It's unlikely that they'd even need to go for a medical in lots of cases. And the other thing is, it can often be arranged through the business. So it's possible that the insurance can be arranged so that the business can pay the premiums, and in that case, the business, this is for UK purposes. Obviously, the business can pay the premiums and obtain UK tax relief, something called a relevant life policy, contain tax relief on the premiums. So all round, the premiums are not going to be very expensive anyway for someone who's relatively young, and it's possible that they can be structured in a way that the business in the UK can get tax relief.
All great ideas. And before we move on to the next case, is there any remaining points you want to raise about this particular case?
Well, I was saying, I mean, on the pension point that you briefly mentioned a minute ago, QJ, it's very difficult for international clients to build up a major sort of what we call a regulated pension entitlement, because they often spend so many years in different countries. And there are sort of schemes out there that enable them to accumulate pension value in tax efficient environments, often in jurisdictions such as Jersey or whatever, with sensible costs. I mean, there are international pension plans out there that are for the most horrendous cost structure that you'd ever see, and they'd be well advised to steer clear of those. But there are ways of building up a sort of a pension pot in a sort of sensible savings scheme in various jurisdictions. And the main aim is to get tax-free accumulation on those savings. So for someone in Noah's situation, it's not likely that being a resident of Singapore or lots of other countries in the world that he'd actually be able to get much tax relief on the contributions that he makes to a pension, which is obviously unlike the case in the UK. If he was a UK resident, then he could pay, up to 40,000 a year into a UK pension scheme and get tax relief. But in a lot of the countries that he's like to be in, there probably won't be much tax relief. So he's not going to get tax relief on the contributions, for instance, in somewhere like Singapore. But at the same time, if he can put money aside for his retirement in a place where he's going to get tax-free accumulation of those savings, then that does give him a pot of money to draw down on one day when he comes to retire many years into the future, if the business perhaps hasn't been as successful as he hopes.
Mm-hmm. That's really helpful. I think a lot of what we talk about is what if and downside protection, right? If you have the upside, the world is yours, no problem. But we want to make sure even in the worst case scenario, you are comfortable. So I think the two key points here, making the estate plan and worldwide will. Yousafa, would you like to comment on this too?
Yeah, sure. So in relation to the worldwide will, there is no wrong or right answer about where the will should be made, but there are a couple of points to bear in mind, because Noah's got a property in France, assets in the UK, and probably will acquire more assets across the globe. So he will need to think about where is best to make the will. So France will have its own succession laws. Generally speaking, they will apply French law to the succession of the French property. So again, my general recommendation would be for Noah to get the will in France, deal with the formalities there, and that stops all the headaches at the end of trying to take an English will to France and probating that to transfer the title of the property to the new heirs. The other thing to think about is if you're putting trust in an English will, if you have a worldwide will that deals with your French estate, then you need to think about what France would accept. For example, France doesn't like the concept of trusts too much. So if you've put something in trust for your children, they will look at that and they will think, oh my God, we're going to tax this. So you could put yourself in really awful situations if you don't align the two jurisdictions together. So wherever my advice to clients of this background would be, if you have assets in multiple jurisdictions, don't just see them in isolation, work together, because the last thing you want to do is you doing something in the UK and then jeopardizing the position in France and vice versa, or doing something in Singapore and then jeopardizing the UK tax position. So everything has got to be aligned and consolidated. And often the advisor, where we see these issues from time to time. So if you know areas to flag for the client, you will know that France doesn't like trust. So the English will is not going to be packed with trust dealing with the French property. So knowing those little bits, I think, is really helpful to avoid issues. And again, with Noah, he's got a child who's a minor. So you might want to think about guardianship provisions. You can put guardianship provisions in an English will. You can do the same in France. But then if you're resident in Singapore and the children are living in Singapore with you, you need to take local advice there to see what happens to the children. Because you can take an English will and say, here's the guardianship clause, but would Singapore accept it? Or any other jurisdiction for that matter. So I think you have to think of the whole picture rather than just, I've got this asset here and there. Look at it globally. Yeah.
Yousafa, just quickly on that point, is there any time you consider having a will in different countries?
Definitely. So for clients in the US, definitely something separate. Especially if you have real estate, so properties in Spain, France, my recommendation would be to get a will there, because the rules will be different. They will want a translation. They will often want statements from the English lawyer to say that this will is valid and it deals with the Spanish assets. So there's a lot of administrative complexities if you're trying to take one will across a number of jurisdictions. There are times when you can have the English will to deal with, say, movable assets like a bank account in Singapore or a bank account in Hong Kong. You can use that because there's no reason why you can't take it there. But other jurisdictions where the language is different, they don't understand things like trusts, for example, your English will's got trust, you could potentially be making things more complicated if you're just using one will. So it depends on the circumstances. And I have a client at the moment where he's got assets in Azerbaijan, Russia, Jersey, Isle of Man. So we're using an English will to deal with the Jersey and Isle of Man assets, but for the Russian and Azerbaijan, we don't want to touch that because they might not accept our will. So for those clients, they then have to take local advice there and see how best to deal with the assets there.
Great. I think that's a very valid point for people to think about. And if you have an international complexity like that, we're happy to have a conversation afterwards to guide you to the right advisor and set up. Even though, Rose cut ourselves, we don't provide tax advice, and just to say it out there, but we work with all the right partners like the two here to help people out. And just before we move on to the second case, I just want to say, if you have any questions, please do share it in the chat function or the Q&A function along the way, so we can, have a look at that during the Q&A and prioritize the questions that may be, shared by most people. So do put in your questions in as we go along. Second case study, let's make this one slightly quicker. It's a gentleman born in Spain in age 42 and moved around different countries until he came to UK 8 years ago and really enjoying the time here. And then he has done some tax reporting back in Spain, and he's thinking about making UK his permanent home. Now he owns, again, properties in his two jurisdictions, have a decent income in the UK, and have assets mostly scattered around in both UK and offshore accounts. And then sitting in cash, and he came to Rosca asking for help and thinking, his cash is really getting taxed away by the inflation, and now becomes a more urgent matter for him to look after. And he has a father who will give him some assets as well. So this is, again, another international background case, but with a slightly more firm, goal, which is stay in the UK for the longer term. So what are the key considerations for this particular client? If Yousafa, would you like to go first?
Yeah, sure. So the same points as Noah, really. What's his domicile? So clearly he says he wants to live in the UK. So the UK is going to tax him on worldwide assets. And then other questions, has he made a will? Is there a Spanish will? Does that Spanish will cancel out the English will? Because it can sometimes do that if it's not coordinated. So again, this consolidation is quite important between the different jurisdictions. What are the provisions for the children? In this example, he's divorced. So if he had made a will before, he needs to check what the impact of the divorce is on that particular will, because under English law, if someone's divorced and they haven't updated their will, any provisions that you put for your divorced ex-spouse would fail. So the gift itself would fail. And if you've appointed them as executors, that would also fail. And if, say, he hadn't made a will, and then he had made a will and he remarries, then that old will be cancelled out by the new will, because we have this law that says marriage cancels out a will. So he needs to always be thinking about his estate planning, even though he thinks he might have done it. If there are changes in his lifestyle or circumstances, he always has to think about what impact that would have on him. Again, just one particular point in relation to the children and the guardianship. Again, think of what would happen on that occasion. Do we need US advisors involved? Do we just deal with it in the UK? And the other point would be, if he is making provisions in an English will, because he's saying it's English domicile, so naturally he'll probably make an English will. He might want provisions for his children who are minors. He might be thinking about putting them into a trust because he thinks, I don't want them to have it until the age of 25, for example. I want them to have it, when they're a bit older and wiser. So then he needs to think about what the trust that he's making in the UK in his will, what the impact of that would be in the US, because the US has stricter rules in relation to foreign trusts. So this this trust that would be created under his will might be classed as a foreign trust from the US perspective, and then query what they think about that. So again, a lot of thinking between the two jurisdictions. What's the best way to make sure his planning is intact for both here and the US? So even though it's his will, we always have to think about where our beneficiaries are, where are they resident, where are they going to be receiving gifts? And again, the same points apply to his father gifting him assets. Where is he gifting it from? What assets is he using? Could I be triggering inheritance tax? Could I be triggering gift taxes? So that's in a nutshell, QJ. I know I've moved on to point 2.
That's a great starting, on sort of the overview. So from what you said, Ken, before, you have helped clients of laying out the plan of gifting their assets to their children. Now here we're dealing with 3 generations. Raul is the middle generation. He's going to receive something from his dad, and he has to think about how to give his assets to his sons or to his children. So if Raul is a client, what are the kind of things you would remind him of? Just on the high level point of, the things he really needs to thinking about today.
Well, I think the first thing, if he were looking to become a client of in a bank like EFG, then we'd be looking at his resident and domicile status. That's the first point, and he's obviously clearly UK resident for tax purposes, but non-UK domiciles. He's claiming that he's got a domicile in Spain, and then we'd be asking a question about whether it is actually worth his while establishing his any investment portfolio he maybe has as on the res non-dom basis, and that would really come down to how much he had invested. So I'm not sure that we've got details of any investment portfolio at the moment,
We said that it's 1 million
Okay, it's got 1 million.
across
Yeah,
3
okay.
locations.
Total. Oh, is that total assets? Does that include property as well, though, possibly? It doesn't matter. But we'd look at basically we'd be looking at the value of his investment portfolio and whether that would make it worthwhile him claiming the remittance basis, because he's been in the UK, I think, for 7 years. So the way this remittance basis works is that for the first 7 years, someone can live in the UK as a resident non-domicile. They don't have to pay any tax on their non-UK income and non-UK capital gains. Once they've been in the UK for 7 years, they then have to start paying an annual remittance charge, which starts at £30,000 per annum. And clearly, it's only worth paying the £30,000 per annum remittance charge if the tax saving is higher than the charge. And so we'd be looking at the value of his investable assets, either the ones he's got now and the ones he's likely to inherit from his father, and trying to decide whether it was worthwhile him setting up a resident non-dom portfolio. And if he did, that would be held outside the UK. It would invest in non-UK citus assets, so no UK securities, no UK shares, etc., all non-UK. And we'd segregate the income and the capital. So any income that arose on the portfolio would be paid into a separate account. And so we'd end up with a capital account, an income account, and possibly also we'd set up at outset something called a clean capital account, which is money that is basically not taxable if brought into the UK. And quite often a res non-dom will be structured in that way. They'll have a clean capital account, which means they can continue to bring money into the UK many years after they've become a UK resident without having to worry about tax. So we'd be looking at potentially structuring at least 3 accounts if he was res non-dom. If we decided actually, you know what, there's just not enough investment portfolio money here to make it worthwhile structuring this guy on a res non-dom basis, then we might look at some other kind of tax efficient wrapper that UK res and dom clients tend to use, something like an insurance wrapper to hold his portfolio, which means that then all the income and gains inside the wrapper can accumulate free of UK tax, perfectly legitimate and used by lots and lots of UK resident individuals. It's a way of deferring tax to the future, but eventually obviously there is a tax charge that comes along. So I think that would be the first thing, trying to determine whether it's worthwhile him claiming res non-dom status. And then probably looking at a bit more detail into his father's situation. Where is his father resident and domiciled? I don't know if we've said that, but if is there likely to be any inheritance or estate taxes on his father's estate one day when the father dies, or does he live in a country or jurisdiction where they don't have estate taxes? I think if the father's living in Spain, then there certainly, I think, would be estate taxes to pay one day. And looking at whether there can be tax efficient gifts made directly to Raoul, or maybe even directly to his father's grandchildren. We could possibly send assets down straight to the grandchildren, maybe using some kind of trust structure to protect the kids themselves if they're in the UK, and some sort of structure like a trust that would be recognised under UK law. So it'd be an awful lot to do at the initial stage and the initial assessment of trying to decide what was best for Raoul and his family.
I think these are all excellent points, especially, before his father makes the actual gift. I think there's a lot of work to be done in this case. And your point about setting up the offshore account, and this is exactly why Rosecut provides offshore accounts for our international clients, because they tend to go from different countries, and having a go-to offshore a port that is tax compliant with the reporting with the UK, and that actually saves a lot of headaches. And we require friendlier minimum than EFT, for example. We can touch on that a bit later on. So in terms of Raoul, is there anything for beyond that writing trust and having a plan for taking the gift from his father? Is there any risk that you see that could incur a big tax bill? Because the gift, if he receives the gift as a recipient, that depends on the jurisdiction rules. He may not have to pay tax on that. But is there any future liabilities? How to strategize this?
you want me to go? Should I go first?
Whoever can. Yeah.
Yeah, I mean, the UK doesn't tax gifts on receipt. So if he receives a gift, from his father into the UK, his father, assuming his father's not resident in the UK, etc., which he's not, then any gift like that is not going to attract any tax on the receipt for all. That's one of the advantages of the UK system. The UK tends to focus on taxing the person that's making the gift. So there might be an advantage to gifting money sooner rather than later. But I think, as I said before, I think a lot of it would come down to where Earl's father is actually living himself, and whether he's living in a country which has punitive estate taxes and inheritance taxes, and whether in fact that country taxes gifts that are made. I mean, the UK, as Yousafa will probably endorse in a moment, the UK has a system of giving a system of potentially exempt transfers, as we call it. So if someone makes a gift in the UK, providing they survive for 7 years, there's no inheritance tax to pay. Other countries, I think, will tax gifts automatically when they're made, and so but there will be a case of doing quite a lot of detailed analysis on Raoul's father, where he lives, what the tax system is there, and whether there's any tax disadvantages to a strategy of early gifting.
Yeah, and just to add to that, from a legal perspective, documentation is quite key, because if we want to ensure that Raoul's father isn't within the scope of UK taxes and these gifts are made outside of the UK, say offshore account to offshore account, then we should document that, because a question that could potentially arise on Raoul's death, if his estate is going through the UK probate system, might be, when did you receive these gifts? Or if the father dies and there's a potential issue with the revenue saying this gift was a UK asset, the documentation will then become quite important to say, this is why it was made. It was an unconditional gift. It was done from non-UK assets to a offshore account, for example. So those little documents become really useful. And obviously you can't write them at the time of death. So you have to
write them after the event. Now, how would you go about creating that sort of document, Yousafa?
So normally for my clients, once we have both father, just say in this case, father and son, on board as to what needs to happen, because what they can't do is just effect the transfer and then we come in at the end. We have to make sure these points and checklists are ticked to make sure nothing goes wrong there for him and for him in the UK. Then we can draft that document, because we will know where it's come from, which accounts are being used, what assets are being used to do the transfer, whether the father is actually non-domiciled, non-resident. So we can put those in that document, essentially. It doesn't need to be a deed. So a deed is like a proper legal document. It can just be a piece of paper that documents. But as long as it's dated, signed, both parties have seen it, so nothing goes wrong at the end. So I can draft those, and I've done a couple for a number of clients.
Another point that strikes me actually looking at it is obviously Raoul's divorced. Is there any risk that gifts made by his father now could be somehow caught up retrospectively in the divorce settlement?
So that's a family law question, but from experience, any gifts, say you've done your divorce and all the financial elements have been completed, I think that is in full and final settlement of what's been decided between the parties. So if the financial arrangements haven't been made, for example, they've just divorced and left finances without looking into things, into looking to agree something, to say what's yours is yours, what's mine is mine, we close things here. If that sort of thing hasn't been done, then yes, there's a potential risk under English law for anything that your husband or wife gets in the future, for you to come back to the courts and claim it, bring proceedings, financial proceedings, to say, we were divorced 10 years ago, but now I want to sort out our finances. So those things can still come in. And I've seen that actually live on one of my client matters, where people come back after 10 years. So although I'm not a family lawyer, I would say if someone is getting divorced, sort out the finances. So that's the clean break from there. And then anything that happens after shouldn't be at risk of being brought back into proceedings.
Well, another thing that strikes me, actually, Yousafa, here is he's non-UK domiciled and is likely to have quite a lot of assets outside the UK. And that's the sort of client we'd probably suggest looked at setting up some kind of non-UK trust sooner rather than later. And EFG has its trust company, just to give a little plug there. But we know we would suggest that he set up some kind of non-UK trust sooner rather than later to hold assets. Do you think, is that the sort of idea you would look at as well, Yousafa? And if so, where would you probably situate the trust?
The trust could be in any jurisdiction. So typically clients go for Jersey, Guernsey, Isle of Man, any of those jurisdictions. But with I think the thing that would concern me with Raoul's case would be his intention to be domiciled in the UK. So we would need to analyze that a bit more, because you don't want to be at risk of this trust then falling foul of the domicile rules, because he might not be deemed domiciled at the moment, but if his intention is to remain here, there's a risk that the revenue could question that these are assets that should fall outside of the inheritance tax remit, i.e. they're not going to be excluded property because of this intention for him to stay here. But definitely for clients where they know that they're not going to be in the UK, or even if they come in, they don't have the intention to remain here permanently, make the UK their home, offshore trust is definitely a good way forward, because you're protecting your foreign assets.
Great. To sum it up, that there's a lot of important steps for the son and the father to take in this case before the gifting happens. And in my personal experiences, we have done a lot of firefighting, tax advice for clients who kind of went ahead with certain important decisions and then realized that they have to resubmit the tax assessment or whatever, patch up work they have to do. So I think the for our audience, don't worry about getting the terminologies right. I think the gist of this whole discussions is for people to realize actually there are certain planning steps needs to happen before major decisions on assets or life events, like such as getting married or getting divorced, or having babies, or all that kind of different life events has an impact on your financial situation and potential liability as well. So I think just be mindful of the time. We're going to quickly finish the 2 case studies here. But if you have further questions on these 2 case studies, please put in the Q&A and as well, just to say, okay, please explain this point more if you didn't get it quite there, or we were technical. So I think, for the next quick few slides, I quickly explain what financial planning comes into play and how we work with advisors like Yousafa and Ken on this, right? So these are the things that we want to bring it to people's mind before they get exciting about, what should I buy and where should I buy it? So the reason being is that, we want people to focus on the big picture. So here are the 2 simple formulas we often repeat, is that your net worth is your assets minus your liability, and your investable assets is your net worth minus your home and emergency cash. So in our first example, Noah has a lot of assets sitting in real estate, but half of it or more than half of it is sitting in the home. So that's not his investable assets, and certainly not liquid investable assets to cover his liabilities. So that's something we often see from our Rose-Card client base, and that puts them in a rather vulnerable position, because how much you own on paper on valuation is one thing, and how liquid they are and how useful they are at the stress moment is another thing. So to be able to get a comfortable position to weather all storms, let's say, it's quite important to do the planning ahead. And what are the other things before you consider investing, right? So first of all, now people having a lot of cash in the bank account, this is not a great thing. The inflation has risen from 2%, 1.5% now to 8, 9, 10%. And even if we bring it down, we think, Rose-Card house view is that it will rarely come back to 2% anytime soon. It may stay at 4, 5%. And that is a real tax on the on the purchasing power, not the monetary value of your cash. So, we say cash is no longer king, and in investment, it really helps you to outrun inflation. Even if it's not guaranteed, it at least provides an opportunity for you to do so. And second is financial freedom needs to be earned. So, these are great examples of clients who have a promising career trajectory and have a lot of assets. But if you say, okay, either of these two cases, if they can stop working tomorrow, the answer is no, because they don't have large enough financial assets to generate large enough income and return to cover their daily expenses. So they have to work. You may choose to work if you have enough assets, but that option of not having to work for money is great. So, with RoseCut, we provide projection and financial freedom evaluation to show you whether you are on track to get there. And the last thing is that financial assets, in our view, should make up the bread and butter component of your investable assets, because simply is compounding, whereas real estate is linear return. So financial assets in most of the past 100 years has provided superior return compared to real estate. And this is why a lot of our RoseCut clients, maybe under the influence of British culture or Chinese culture, has bought properties and realized it's too hard to manage, and it did not make money as easily as they thought, and they pay a lot of income tax on that. So they decided to get rid of the real estate and hand over the cash to us. And we put two real client cases here to show you, what are the vulnerabilities in their setup, despite they're very wealthy on paper. So that's a quick rundown of the key points on what RoseCut thinks on this kind of things. And here is a few snapshot of what we can. So we are a digital wealth manager with both Android and iPhone apps, and we have private banking alike service, but we don't buy you the Michelin star at lunch, unlike the private banks. And we have a unique setup for global citizens. So we provide both UK and offshore accounts. And to my knowledge, we're the only one that allow you to have an offshore account in Jersey or Leicester, subject to eligibility and the size of account, to enjoy some of the tax optimization we just talked about. And we have the full suite of the UK accounts, general account, ISA, junior ISA, and pension, if you are committed to stay in the UK as well. And we use 3 different custodians to achieve that. Financial planning usually costs people thousands of pounds to talk to an advisor, but now we have built it into a free product to show you and give you a review of where you are, and some honest feelings, such as you have very low liquidity. And this is, by the way, this is a new feature to be launched by the end of this month or beginning of the next month. So please look out for that. And this is something we're trying to help people to understand before they dab around in investment. That is like, without a tech stack, without a design of the architecture, you started coding. You may be coding something you entirely don't need or don't want down the line. And here we get you to focus on your lifetime cash flow projection. This is where you will see exactly when your investment will be able to help you to reach financial freedom. Then you're free to do whatever you want. You maybe want to do some volunteering work, or you may want to travel the world for the next 10 years. It's whatever you want. But before that, we need to carefully plan for that to happen. Part of it is coming from investment returns. Part of it is from tax optimization. And we're talking about all encouraged tax optimizations by the government. So, nothing is you read in the funny newspapers. And then we show you, exactly when you're going to reach financial freedom with what kind of assets. And hopefully that gives you a clear picture of why you are investing for. And throughout this process, we work with advisors like Yousafa to help you to do the right infrastructure, create the right setup for you to achieve that. Saving tax is like, creating additional return and help you to get there faster. So here, let's take a quick poll on the questions on the topics you want to hear next, and give us feedback on what you think about the webinar today. We decided to try a new format today, and it's more technical than the typical one, but hopefully, it hasn't bored people too much. And could we quickly get you to give us your answers on this, please? I'll pause for 30 seconds. And now let's look at the Q&As. So there's a first question from Miguel. For dual citizen, UK and African country, who is an employee who works in the UK for an American company. And this is, again, very typical in the London taxing, different nationalities and companies and personal nationalities mixing up. And so this US company granted the employee stock options. So what is the best way to protect against a huge tax bill? Is early exercise worth it? And how does one reduce that tax rate? So, for your understanding, the tech companies will give employees part of their comp as stock options, but these are options, not actual shares in the business. The employees can choose to exercise it and pay a small nominal value for that. And hopefully the value of the business will grow, right? So, so they usually might have some EMI sort of tax efficiency schemes, may not if it's a US company. So what's your view on this? How to protect this employee stock option against a huge tax bill?
I mean, just chipping in, QJ, is obviously quite outside my area of expertise, and it's possible that Yousafa will have colleagues in her business that will know quite a lot about this sort of very specialist area. But just to give a brief bit of insight into this, which comes with a disclaimer. I mean, in the UK, obviously, we have quite a difference between our income tax rates, which go up to 45%, and capital gains tax rates, which are 20% in most cases. So the logical planning is to try and get, in these situations, get as much of the tax charge that arises into capital gains tax as possible and away from income tax. That's the piece of planning that can be difficult to achieve, but can make a lot of sense. The exercise of a share option, generally the point of exercise, there is a charge to income tax. And as I say, this comes with a disclaimer because it's not my specialist area, but there's generally a charge to income tax on the exercise of a share option. It's the difference is generally, the tax charge is generally based on the market value of the share at the point of that exercise, less the amount that's paid for the option itself. And so that gives rise to a gain, and that gain is then added to one's income for the year and charged to income tax. Once the shares have been exercised, however, and you actually own them outright at that point, then any future increase in value is subject to capital gains tax in the UK, and that's levied at a much lower rate, as I said at the start, 20%. So the planning here is to try and exercise as early as you can, providing there's obviously a point in exercising and there's some profit there to exercise, and get as much of the gain in the shares themselves into capital gains tax and out of income tax as possible. The second point I think that Miguel's made is how does one protect the shares upon sale in a number of years, use an offshore account. I mean, if on the basis that Miguel is non-UK domiciled, then I think providing he was able to exercise the shares at a fairly early stage, the options at a fairly early stage, take ownership of the shares, and on the basis that it's a non-UK company, then I think he could place those shares in some sort of outside the UK, possibly in a non-UK trust, and that would help to keep the UK tax liability down in the future as well. So there's quite a lot of planning that can be done there for someone like Miguel. The last point was the last question: if the employee leaves the company in say 5 years to live somewhere else, is there still a UK tax liability? Again, I'm sorry to keep making this point about coming with a big disclaimer, but this isn't really my area of expertise. I think my basic understanding of that is if you exercise share options Once you're non-UK resident and those relate to a previous UK employment, then the UK income tax liability still arises. If you've already exercised the options, paid your income tax, and have taken direct ownership of the shares, then once you've left the UK and become non-UK resident, it might be possible to sell those shares without having to pay UK capital gains tax, providing that the individual doesn't come back into the UK within, I think, 6 complete tax years. So that's my contribution towards those 3 quite complicated questions. I don't know if you've got anything to add, Yousafa, on that.
1 second. No, those were spot on. I would say that it is very specialist. So if you do need to speak to somebody outside, we have a partner in one of our teams that would be able to help you, and hopefully with more detail, he'll be able to guide you.
And then I think the next question we've got is for someone asking how they go about becoming a non-dom. Maybe that's one for you, Yousafa.
1 second, before we move on to the next
Sorry.
question, I'll just chip on this as well. So from a tech company perspective, it's a lot depending on the employee stock option scheme that's been set up for you. So Miguel, the first thing is that you check with the company policy, what's the exercise price and what's the timing of the exercising, and what is the leaver's term. For example, if you leave the company and wait, you typically have only a 90 days window of exercising that. Then it becomes a preparation of your cash flow before you leave the company. Yeah. So one, pay attention to the company terms, and second is that Ken's comment on, if you exercise now, you pay capital gain tax. Pay income tax on that. But you only pay capital gain tax on that later. And if you're not a UK tax resident at that time, at least there's something sorted out there. But if you're going to exercise the shares, not just looking at the potential tax bill, it also should be a vote of confidence in your company as well. Yeah, because all these unlisted companies have a chance of, the shares have a chance of not worth anything. Whether it's a 90% chance of not worth anything, or only 10% chance as a company is really close to IPO, then this is a commercial decision rather than a tax decision. You only exercise the shares that if you are confident in the future of the company. Yeah, that said, I can tell you out of my interactions with founders or early employees of the companies, 9 out of 10 really regret walking away from some sort of stock options. They felt like the company was not doing great, and that's why they left. But then that stock option ended up worth a lot of money, and I often hear regrets that way. So I just wanted to add some founders' perspectives on this for your consideration as well. Now, moving on to the next one, and if I need to become a non-dom, where do I start, Yousafa?
So this really depends on your resident status, because you can't choose whether you become non-dom or dom. You have to fit the criteria. So we'd be looking at the number of years you've been resident in the UK, and if you are eligible. So as a UK person, you can't become non-dom because you'll have the UK domicile of origin. But if, say, you're you've come from France, yes, we can look at how many years you've been in the UK, whether you fit in the non-dom rules, and then afterwards the benefits of becoming non-dom, because I assume you probably want to claim the remittance basis of taxation. And if you do, you have to weigh up the merits, because there is that charge after 7 years. So is it worth doing it? Is it not worth doing it? But yes, so you can speak to a lawyer about this, or accountants as well, possibly. Ken, do you think private bank would be able to help with this?
No.
Well, we'd certainly be able to outline the criteria. Yeah, I mean, as you say, Yousafa, it depends where someone comes from originally. Whether they'd be able to claim res non-dom status or not. If they've been like me, they spent all their life in the UK. It'd be very difficult to suddenly claim that they had a domicile somewhere else. But as in a couple of the examples that we used in the case studies, those individuals could clearly, if they were in the UK, because one was from France, one was from Spain, they could clearly claim non-dom status. And I would suggest that to do that, you go and speak to a tax advisor, can be an accountant or a lawyer, and just have a chat with them about how you go about registering. Generally, I think it's through the tax return process. So when someone when you submit a tax return each year, you have the ability then to claim the remittance basis, and once you claim the remittance basis, HMRC may then question on what basis you're actually claiming that.
Yeah, so just to sum it up, whether you're non-dom or not, you're born with it. Yeah, if you were born to a British father and a British grandfather, that sort of thing in the UK, then chances are you are dom, and you can't claim non-dom on that. If you were born in a different country with different with other than British parents, father and grandfathers, then you have a chance, and you can talk to a tax advisor about it. And one of the confusing part is that tax advisor can be a tax accountant or can be a lawyer. They can do the same thing, but there are other type of accountants and other types of lawyers as well. So make sure you speak to a tax advisor there. The next question, I think I'll take it because it's about investment. It says, with inflation, should I keep money in places like nutmeg? So first of all, we would say, you have cash, like cash or term deposit is a type of cash as well. And you have financial investments such as the portfolios made by nutmeg, or the portfolios made by Rosecud, or you'd open a trading account and started buying Google versus Tesla. I would say cash is the worst option because you basically lose any chance of making a positive return and beating inflation. You are being taxed by the inflation gradually and surely on an annual basis. Now, the second worst option is to dab around investing yourself, because most people don't have the time or the expertise to do it. There's a reason why this is a profession, just like a doctor. Yeah, so they need to go through years of training and experiences in the market to make the right decisions. So you'd rather hand it over to some professional managers. So nutmeg is one and Rosecud is another one. And I would say Rosecud performance for the past 3 years beats nutmeg most of the time across the different risk levels. Yeah. So if you are thinking about giving your money to someone to manage, check their performances and check their fees and make sure you pay for the performance. Yeah. So this is the whole point of portfolio management. And of course, Rosecud provide additional value add services like inviting you to interesting webinars and speaking to experts for free. So, advice on becoming a wealth planning manager, if this kind of career is interesting to you. We don't know that one, but Ken, maybe you can just share a few words quickly on.
Well, I mean,
what you like or what you don't like.
I'm happy to, if they send you an email, QJ. The name's gone now, unfortunately, but if they send you an email, I'm happy to reply to that.
Okay, great. And the last question, so what if company offers someone RSU restricted stock units with dual nationality? This question is not super clear to me. Restricted stock units is basically employee options, and there's always some sort of
they're generally I think, again, with disclaimers, but I think restricted stock units are generally granted, and then they vest sometime later, and the income tax liability arises at the time the units vest. Mm-hmm. It's generally deducted through the pay-as-you-earn system. Okay.
Yeah, so
I'm not sure about the dual nationality. I'm not quite sure what that is. Does that mean the dual nationality of the individual?
Yes, that's my read of the question. I think, maybe if you can answer along the lines of actually nationality matters less in terms of the tax residency of this individual at this time, right? Because you could be having dual nationalities of French and US and living in the UK and receiving the stock options from a UK company, and the UK tax rules apply here.
Yeah, agreed.
So I think it's I hope today's webinar helps to establish a couple of concepts in people's mind, right? So what's your passport nationality is not necessarily the same as your tax residency, is not necessarily the same as your domicile. And what matters more is your tax residency, you know, in terms of your tax planning and your future plans. So I hope today's webinar, you guys find it helpful, and thank you for 22 votes on the webinar poll. Thank you very much. And the full webinar is recorded and will be published later on our YouTube channel. So if you would like to revisit that, please search Rose Cutting YouTube. And thank you all for attending, and thanks our two amazing speakers for today.
Thank you so much.
It was a pleasure. Yeah.
Thank you both. Bye for now.
Goodbye.